Hi, this is Dipinder Virk, and I'm going to talk about case study 1, that is Baker versus Canada 1999, and I'll be answering all 3 questions within the assignment. Before going ahead with the case, I want to give a brief background who Mavis Baker is. Mavis Baker, during the time of the case, was Jamaican citizen, came to Canada on visitor visa in August 1981 and did not leave Canada, and she overstayed her visitor visa. She worked as a domestic help for next 11 years, and she never applied for permanent status, permanent resident status or any other status. In 1992, she was summoned to be deported, but she filed a case under Section 114, Clause 2 of Immigration Act 1985 to grant her permanent resident on humanitarian and compassionate grounds within Canada. This was done in 1993. Mavis Baker, she at that point of time she had 4 children who were Canadian citizens, 4 in Jamaica, so total of 8. And she was also suffering from postpartum psychosis, and she was diagnosed with schizophrenia, paranoid schizophrenia. She did apply for the welfare at that time, and her appeal was rejected in 1994 by Senior Immigration Officer Karen based on the conclusion of investigating Officer Lawrence notes. Her deportation was stayed pending as a result of the appeal she did in higher courts. Some of the relevant statutory provisions and the treaties which were highlighted in this case were Immigration Act of 1985, Section 82.1, 83.1, Section 114, Clause 2, which says the Governor Council may by regulation authorize the Minister to exempt any person from any regulation made under the subsection 1 or otherwise facilitate the admission of any person where the Minister is satisfied that the person should be exempted from that regulation, or that person's admission should be facilitated owing to the existence of compassionate or humanitarian considerations. Another relevant law or the international treaty is the Convention on Rights of Child, which Canada ratified in. Under this convention, Article 3, Article 9 and Article 12 are pretty important. The Clause 1 or the Part 1 in Article 3 explicitly says, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interest of the child should be a primary consideration. After that, after her appeal was rejected by the case was rejected by the immigration officer, there were 2 judgments, one by the Federal Court Trial Division in 1985, and mainly getting the treaty or the convention into the case made whether the treaty was applicable or not. It became a serious question of general importance under Section 83.1, and according to the judge at that time in the federal court, the treaty cannot have a legal effect in Canada unless implemented through a domestic legislation or it is incorporated into the law, into the Canadian law. But the court did say that the rights of the child should be taken into consideration as the primary factor. Now, the primary factor thing or the primary factor statement while accessing the application was not agreed by the Federal Court of Appeal in 1997, and it says like it has importance, but it does not have. Now I want to highlight the issues that were highlighted during this case. And before that, she in her case, she supported some letters. The first letter was in the letter it said like it showed the concern whether she will be getting the proper medical treatment in her home country, and she doubted that. Another was the effect her departure will have on her children mentally. And another point was the emotional hardship she will be going through when she will be leaving Canada. So these were the 3 points that were highlighted, and the convention was explicitly used, the articles of the convention. Now, the first thing first, under section 83, the question of general importance was certified and it was sent to the Higher Court of Appeal, and that whether the question is positive or negative, whether the convention is to be incorporated or not, was one of the issues. Now, second issue was whether the procedure of whether the principle of procedural fairness was violated in this case by the visa officer, and within the principle of procedural fairness, the participatory rights, apprehension of bias by the visa officer, the discretionary powers of the officers and the people concerned were all taken up. Another the major highlight of the case was the best interest of the child, how to define that, how to set up the boundaries. So the honorable judges, they said the immigration officers who make H1 citizens are provided with a set of guidelines contained in chapter 9 of Immigration Manual, examination and enforcement, especially the guidelines in 9.0, which emphasizes the officer have a duty to decide the cases, which cases should be given favorable recommendation by carefully considering all aspects of cases, not just the hardship test. Using their best judgment and asking themselves what a reasonable person would do in such statements. So it's very important. These are the parameters they have set up. Another one is the guideline under 9.07. The immigration officers are instructed to assure themselves first whether a public policy consideration is present, and if there is none, whether the humanitarian and compassionate circumstances are. So first thing first is the public policy consideration, and second thing is the humanitarian and compassionate circumstances. Now, for judicial, the procedural fairness, there were some factors given. This is not an exhaustive list, but in the case they defined 5 factors. So the number 1 was the nature of decision being made and process followed in making it. The nature of the statutory scheme and terms of statutory pursuant to which body operates. The importance of decision of the individual or individuals affected, how the individuals will be affected by the decision. The legitimate expectations of the person challenging the decision, what his or her expectations are. The choice of procedure made by agency itself. So when we come to the participatory rights, the court said yes, there's no problem with the participatory rights because the opportunity was provided, full and complete written documentation was sufficient as a participatory right, and there is no oral statements needed or any thing else is needed because already they have been given the opportunity to provide the documentation. Also, it was appropriate to recognize that in certain circumstances, including when the decision has important significance or individual, or when there is a statutory right of appeal, the duty of procedural fairness will right or require a written explanation for the decision. But in this case, by Officer Cadden, a written explanation was not given. But still, there were notes of Junior Investigation Officer Lawrence, and those notes were included as an important proof of providing how the decision was reached, how the decision was taken by the officer, and these notes were pretty important. Now, based on these notes, the court, the judge, he went to the next step for the apprehension of the bias under the procedural fairness. So, procedural fairness always requires a decision to be made free from the reasonable apprehension of bias by an impartial decision maker. So the decision maker is the immigration officer in this case. This duty applies to all immigration officers. It's not about the senior immigration officer, it's not about the junior immigration officer, it applies to all immigration officers. That was outrightly said by the court. Because they necessarily relate to the people of diverse backgrounds from different cultures, races, continents, immigration decisions demand the sensitivity and understanding by making those decisions. So you cannot pick and choose, you cannot discriminate people based on their backgrounds, based upon their races, based on their culture. So they require a recognition of the diversity because Canada is a multicultural, diversified country, and also understanding about others. So the court said, as far as the statement in the immigration officer's note is concerned, it doesn't give any impression that he was drawing the conclusion based on evidence. He was trying to prejudice, he was just trying to make his own conclusions, his own So another factor the court took into consideration under the procedural fairness was the discretion, and the discretion has a lot of range, I can say. A discretion can have a lot of outcomes. A discretion can have a specified outcome. A discretion can have a limited outcome. So it all depends about what kind of options, what kind of choices are given to a decision maker. So according to that, you make your discretion in the case. In this case, how to outline the discretionary powers, how to take the discretionary power. The court said they need to take, the decision makers need to take a pragmatic and functional framework of the court decisions. They have to make that boundary, they have to set up those boundaries, and boundaries imposed by the statute, the principal rule of law, principle of administrative law, fundamental values of the Canadian society, and principle of the charter. So these were the boundaries set up by the code, which are to be taken into consideration for taking a discretionary measure or a discretionary. Now the highlight of the case was how to define the best interest of the child under agency. The court said the wording of the legislation shows Parliament's intention that a decision be made in a humanitarian and compassionate manner. A reasonable exercise of the power conferred by section requires close attention to the interest and needs of the child. So we're not talking about any international law. We're talking about the legislation given by the Parliament. So a reasonable power of the exercise conferred by section requires close attention to the child, since child's rights and attention to their interest are central, humanitarian and compassionate value of Canadian society. So court said the interest of the child and needs of the child are the central humanitarian and compassionate values of a Canadian society. So we're not taking international laws into consideration or any conventions. So court was very, very specific. Indication of these values may be found in the purpose of the Act, in international instruments, and in Minister's guidelines for making humanitarian and compassionate decisions. Because the reason for the decision did not indicate that it was made in a manner which was alive, attentive, or sensitive to the interest of the applicant children. This is very important, alive, attentive, or sensitive. So it has to be alive, attentive, or sensitive to the interest of the applicant's children, and did not consider them as an important factor in making decision. It was an unreasonable exercise on the behalf of the officer, and the powers configured by the legislation. In addition, the reason for decision failed to give sufficient weight or consideration to the hardship. So we are talking about 2 points. One is the best interest of the child, what will be the best interest of the child, and secondly, the hardship she will be enduring. And in the hardship test, it's unusual and undeserved or disproportionate hardship. So we have those thresholds, which will be a lot of points will be clarified in Kenthasme versus Canada case. So, but this is like this was in 1999, so it is a precursor of Kenthasme. Court also said the principle that an international convention ratified by the executive has no force or effect within the Canadian legal system. So when we talk about convention of the Convention on the Rights of the Child, it has no legal effect or binding on Canadian law, courts, or their decision making. And until unless they are incorporated in domestic law and does not survive intact the adoption of a principle of law which permits reference to an unincorporated convention during the process of statutory interpretation. So the court doesn't want the executives or the legislators to be too powerful to ratify a treaty and then meddle in the affairs of the court through those treaties. So they are very, very specific. So they don't want any international law to be referenced or be used in local. So now we have a definition of best interest of the child defined as indicative as indicated in the legislation. So on the basis of that, the CIC, it gives humanitarian and compassionate assessment, best interest of the child. So this is given by CIC, they have properly defined. And it says that the decision of humanitarian compassionate application must include an assessment of the best interest of any child directly affected by the decision. So this is the first thing a consultant needs to do. As a consultant, I need to do this thing. I have to find how the interests of the child are being affected. So I need to contact that. I need to provide details of that, how the child interests are being affected by the decision if anything goes wrong. Any child directly affected in this context means Canadian or foreign-born child. So it can be a Canadian child, it can be a foreign-born child. So we need to show a correlation between the effect. The relationship between the applicant and any child directly affected need not necessarily be that of parent and child, but could be another relation that is affected by the decision. So it can be any relation. It is not about parents and their children, and it can be a grandparent and a primary caregiver. Now, when we have to take the consideration. When we have to take into consideration the material submitted, then application relies whole or part, or at least in part, on this factor. The applicant has the burden. So it is not the only or the sole factor. We have to take into consideration other factors also, but this is an important factor. This is not a primary factor. That's totally defined. So not only we need to highlight the other factors, we have to really take into this factor, and it is the applicant's burden of justifying the basis of their agency submission. So we have to justify this. As a consultant, we need the evidence that decision makers are alert, alive, and sensitive to best interest of the child. This is like Baker versus Canada, already defined. As children, they experience greater hardship. In Kenthasme versus Canada, the hardship test was made inapplicable for the children. So that's something done after Kenthasme, and but the adults, they still have to pay. So on the basis of the CIC guidelines, the main factors I would say an immigration consultant need to consider are the child's emotional, social, cultural, and physical welfare, to be taken into consideration. And some example of the factors are the age of the child, the level of dependency between the child and the HNC applicant, the degree of child's establishment in Canada, the child's link to the country in relation to which HNC assessment is being considered, the condition of that country and potential impact on the child, medical issues or special needs the child may have, the impact to child's education, matters related to child's gender. The facts surrounding the decision under 825 may sometimes give rise to issues whether the decision would place a child directly affected in a situation of risk. The issue of risk may arise regardless of whether the child is a Canadian or foreign born. So we have to take into consideration. So I would like to conclude this is a pretty important decision, and this decision has affected many court decisions, especially where the children were involved or the child was involved, and the immigration consultant has to really dig into the factors that can affect the child and make a proper case, and how much we can justify ourselves, how much we can justify our case, and how much correlation we can give to the case is really important as an immigration consultant.